Hello everyone, my name is Yulia Vikhat and I'm a family lawyer. I work at the law company of the lawyer Alexey Nikolaevich Skryabin. Our law company specializes in providing legal services in the field of marriage dissolution and recovery of alimony. Our lawyers provide support in court proceedings throughout Ukraine. In this video, I will tell you about the procedure of the unilateral divorce through the court, how to divorce through the court on the basis of a common statement, how long does a divorce throughout the court with children take, how does a statement of claim for divorce look like, what does a sample of a divorce statement look like in 2021, what documents are necessary for filing the divorce through the court, what documents do the former spouses receive upon divorce through the court. Watch this video till the end in order to learn a lot of interesting information about divorce through the court if you have children. Subscribe to my channel to receive up-to-date information in the field of family law. Contacts for calling me and for asking about paid consultations are under this video. The divorce procedure through the court unilaterally in Ukraine. According to the Family Code, it enshrines the right of spouses to file a divorce statement unilaterally. Compared with a divorce based on a common statement of spouses who have children, and a divorce by a registry office at the request of spouses who have no children. A divorce at the request of one of the spouses causes a situation when only one of the spouses seeks to end the marriage, while the other doesn't want it. Such an order is one-sided. How to get a divorce through the court in Ukraine on the basis of a common statement. In cases of divorce through the court based on the statement of spouses who have children, according to the Family Code of Ukraine, there should always be two applicants of the case, each of the spouses. If only one of the spouses wants to dissolve the marriage, the corresponding category of cases of characterized by the presence of a dispute about the right. In this connection, it is a subject for consideration in the order of another type of legal proceedings, writ proceeding. According to the Family Code of Ukraine, it determines the presence of mutual certainty and agreement on the following issues: whom of the parents the children will live with, what kind of participation in ensuring their living conditions will be ensured by the one who will live separately, as well as on the conditions for exercising the right to personal upbringing of children. All details should be reflected in the parents' notarized agreement. How long does a divorce with children in Ukraine take through the court? The time limit of divorce depends on the court proceedings in which the application for divorce and the whole case are considered. It should be noted that a divorce based on the common statement of spouses who have children is carried out in a special simplified procedure and takes 1 or 2 months, depending on the nuances of the cases. Divorce in a writ proceeding lasts longer because the key issue is the possibility of objection by the other spouse and deliberate delay in the consideration of the divorce statement. In this case, the consideration of the divorce through the court lasts for 4 or 6 months. The Statement of Claim for Divorce in Ukraine, Sample 2021. The Code of Civil Procedure Ukraine clearly shows the relationship between such concepts as claim and the statement of claim. The application is submitted to the court by filing a statement of claim for divorce. So the statement of claim for divorce is a procedural document, in the content of which the claim is displayed. While the statement itself acts as a reasonable claim of the plaintiff against the defendant and the court. In the first case, the requirement is aimed at protecting violated rights, freedoms, and interests, and in the second, at the administration of justice in a civil case. If the statement of claim is an exclusively procedural category, then the claim has a complex nature as the theory of civil procedure distinguishes claim in the material sense, namely the claim of the plaintiff against the defendant based on the norms of substantive law, and claim in the procedural sense, in particular the claim of the plaintiff to the court based on the norms of civil procedural law. A divorce claim consists of such structural elements as content, subject matter, and grounds, which are reflected in the requirements of the statement of claim. A sample of divorce statement of claim in 2021 can be found on the website Advocate Family. What documents should be submitted for divorce through the courts in Ukraine? According to the Code of Civil Procedure, it should be noted that the plaintiff should attach to the statement of claim for divorce its copies and copies of all documents that are added to it, in accordance with the number of defendants and third parties. Documents confirming the payment of the court fee are attached to the statement of claim for divorce too. The plaintiff is obliged to attach to the statement of claim all the evidences he or she has confirming the circumstances on which the claim is based. A power of attorney or the other document confirming the powers of the plaintiff's representative is attached to the statement of claim for divorce signed by the plaintiff's representative. Thus, it is necessary to submit to the court claims, receipt for payment of court fee, copy of passport and tax identification number, copy of marriage certificate, copy of birth certificates of children if there are common children. Court decision after divorce, a document on marriage dissolution through a court in Ukraine. Despite the fact that the marriage terminated on the day the court decision on divorce comes into force, with all the consequences, entering information into the state register and putting a mark in the marriage record is still necessary. Therefore, in cases of divorce in court, the Department of State Registration of Acts of Civil Status, which received a court decision on the divorce, must, on the day of its receipt, make a mark about the divorce on the front side of the marriage record, indicating the date and number of the court decision, the full name of the court that made the judgment, as well as enter the relevant information into the state register. After that, the Department of State Registration of Acts of Civil Status notifies the archive of the body of the State Registration of Acts of Civil Status, in which the second copy of the marriage certificate is stored, which makes an appropriate mark in it. Consulting a professional divorce lawyer is a guarantee of your success. Contact the lawyers of our company in any way convenient for you. Call or write to messengers, and we will help you to resolve your issues quickly and efficiently. If you have a need for consultation or paid services of our lawyers, then contact the contacts listed under this video. If you have any questions, then write them into the comments to this video, and I will definitely answer you. If this video was useful for you and you learned something new about divorce through the court, if you have children, then like this video, subscribe to my channel, share with friends, press the bell not to miss new videos, and see you in new videos.